On the eve of the special legislative session in Tallahassee, we ask ourselves, are there too many lawsuits in the state of Florida associated with insurance policies? Do insurance companies suffer at the hands of assignment of benefits provisions that are hidden in roofing contracts? And are they paying out millions and maybe even billions of dollars in contingency fee multipliers? Hi, you've got Ted Corless with the Corless Law Group. Very excited to jump into this important topic, very timely, and certainly it's time that we push back a little bit on some of the information that's being spread by Governor DeSantis and other lobbyists working directly with some of the largest and most powerful insurance companies in the United States. Again, my name is Ted Corless, and for the last 26 plus years, I have been in the business of property insurance. Sound boring? No way. In fact, I get to play with all kinds of fun scientific ideas, things associated with structural failures, hurricanes causing massive damage to 25-story buildings, and sinkholes that gobble up buildings and people in ways that are unimaginable. But today we're going to address some of the very specific arguments that are being bandied around by representatives in the state of Florida to justify what we believe will happen in these following weeks pursuant to a new legislative session that has been brought on by Governor DeSantis and other representatives. Let's begin with this idea of, are there too many lawsuits in the state of Florida associated with property claims? I frankly have not been able to locate a copy of the report that was submitted by the Office of Insurance Regulation that claims 76% of the United States lawsuits associated with property insurance take place here in the Sunshine State. I have no way of evaluating whether or not that number is accurate or even what the source of it is. I can tell you that they are presenting it from the perspective of the fact that even though Florida only has 8% of the population, we have 76% of the lawsuits. Let's talk about the state of Florida. Are we a pretty good sized state when it comes to a coastline? Well, yes. In fact, you may not even realize this, but if you look at the 48 contiguous states, we have the most coastline of any state. In fact, if you compare it even to California has 840 miles of general coastline. Florida has almost double that, approximately 150% of that at 1,350 miles. And that would mean that we probably end up with the largest number of properties that are exposed to coastline. And the Florida coastline is brutal when it comes to humidity, in terms of the kinds of decay that humidity can cause, or storm activity that hits us in all directions, north, south, east, west. Florida has a real tough go of it when it comes to Mother Nature. We think Mother Nature might like to ski and probably doesn't like to boat very much because, boy, does she send a lot of water our direction. So let's start there. And that is, would you expect that Florida would have the most lawsuits for property insurance? Well, I suspect there may be thousands, and I'm going to say well into the thousands of developments that live in tall buildings that pepper our coastline. And those make for lovely targets when hurricanes come roaring past us. We are routinely told that Florida can expect to have anywhere from 3 to 5 impact storms in a given year. And then when you compare that to other states, what other states have those kinds of issues? Well, my mother state of the state of Missouri, you remember the name of that hurricane that hit the state of Missouri? That's right, neither do I, because it's never happened. And the reality is, of course, there are going to be an excessive number of lawsuits associated with these kinds of events. Hell, look at the amount of money that was just paid on the Surfside collapse. $997 million. Somebody couldn't come up with the extra $3 million just so we call it an even billion. But here what we've got is a circumstance where you understand the cost of repairs associated with these tall buildings. Many of these buildings, condominiums that are anywhere from 2 stories, 4 stories, or 25 stories, have enormous costs associated with anything that takes place with them. And so the bigger the prize, the more commonly you would expect to find a lawsuit. Now, is it fair to say that insurance companies are probably more likely to be the cause of all this litigation? Well, I think the answer is probably somewhere in the middle. And we'll get to some of the details and the reasons for that. But let me give you an illustration. I have represented, and most of my clients are individual entities, condominium associations, or I represent property managers. Most commonly, my clients are boards of directors who are responsible for the upkeep, maintenance, and interface with insurance companies when it comes to these kinds of issues. And so if you can imagine that an insurance company comes out to one of our properties following Hurricane Irma, I won't mention the insurance company lest I get their wrath. But let's just say they came out after Hurricane Irma. September 10th was the month. It was later in the year. Big bad storm Irma came, and Irma caused a lot of damage. The original assessment of the building by the insurance company after 4 months was approximately $225,000 worth of damage. They submitted the estimate, which we reviewed, and we immediately noticed enormous categories, significant categories of building components that were not included in the estimate. By way of illustration, according to them, the 7-year-old roof was not damaged in any way, and they had the amount of damage at 0. Second, they had virtually no damage reported to any of the windows. Okay. And then what about doors? Well, doors are important because doors face the outside and they're sealed to keep water out and wind away. But what do we get? We get an estimate for $225,000, and we submit this to our own group of experts. Now, I'm pretty cautious. I won't use the word conservative because that word confuses me in a modern age. I don't know what the hell conservative is anymore because I sure see a lot of people doing things who claim to be conservatives, and that doesn't seem very conservative. But here I'm going to say I'm cautious about who it is that I hire. And we hired an engineering firm that spends more than 50% of its time working for large insurance companies. And so when we presented our own estimate, we submitted it to them, and we included things like the windows and the doors and the roof. The insurance company scoffed at that and told us they weren't going to pay it. And so we suggested to them that instead of litigating the case, let's use a provision within their own policy for the assessment of whether or not there is a real dispute, a bona fide dispute over the amount of the repairs. All right, so here it comes, and they respond, and they begrudgingly agreed to participate in that process. Now, it's a very expensive process for a couple of reasons. First and foremost, we have to pay our own consultants. It doesn't come out of the money in the insurance policy. And these consultants are very expensive because they have to do inspections on these buildings. And many of these buildings, you'd be surprised just how many windows there are. One building in particular had 1,200 windows. I couldn't even imagine that, but that's what we're talking about. And then we started to discover that some of these windows were relatively new. They were still within their lifespan, but they were not holding water the way they were supposed to. They weren't able to repel it. We produced years of maintenance records showing the insurance company that the property had been properly maintained. And so here we go into what is commonly referred to as appraisal. The appraisal is an opportunity for the insurance company to put its estimate in front of a panel of professionals that they have input into who those individuals are. And we did the same. And so $225,000 was their estimate. So the first estimate that came in was at the time the claim was made, and that was approximately 1/3 of the policy's deductible. That means that the amount of money really didn't matter. They weren't paying anything because it was below the deductible. And so we go into the appraisal process and we immediately notice something very interesting. They hired a new consultant, and that consultant produced yet another estimate. Well, now we notice that the estimate by the insurance company's own company is $1.6 million for the damages. Wait a second. I thought you said that the damages were $225,000. No. Oh, it's at least 1.5, 1.6 range. All right. So there's the first bell I'm going to ring. Wouldn't you figure if an insurance company is approximately, 10, 20% of the real number, they're probably going to get sued for not doing an appropriate investigation. But they don't like to do those investigations because they're expensive and they come out of their end of the equation. But we go ahead and we go through the appraisal process, and the estimate that we had produced was approximately $3.9 million compared to their 1.6. The panel of experts, again, selected mutually by the insured and the insurance company, ultimately determined that the cost of the repairs were $3.65 million. That would mean that approximately 13 and a half times the original estimate that was produced by the insurance company, and more than double the number that they hit the second time around. That seems to me to be a real good opportunity for the parties to get involved in litigation. But the story doesn't end there. The amount of time that it took us to resolve this issue with the insurance company was just short of 3 years after the original claim was submitted. For those of you who are in the home improvement business or have been to Home Depot in the last couple of years, you've noticed something dramatic, and that is the cost of materials has gone up wildly. Now, that matters here because in a case like the one I just described to you, the delay resulted in the cost of materials actually going up even higher, meaning that we have an estimate for $3.65 million. But what was the real number after the insured completed the repairs? Well, according to the appraisal provision, you only get the number that you were awarded, the $3.65 million. But what was the actual cost of repairing the roof, the windows, and the doors? It was $5.3 million, which means that from the original assessment, the total cost of repairs went up 25 times the value that the insurance company had placed upon the loss. And at the same time, forcing the insured to go through this appraisal process cost them hundreds of thousands of dollars in attorney's fees and costs associated with experts. And so would Governor DeSantis take the position that if a lawsuit was later filed for bad faith, and there was, would you figure that that's the insured's fault that we're in litigation? Does that fall into that 76% of the global litigation crisis here in Florida? I say it isn't. All right. So that's one perspective on the number of lawsuits. What other reasons could there be other than nefarious public adjusters, evil plaintiffs' lawyers, myself included among them, and overly greedy property owners? What are some of the other reasons, other than the fact that we have the largest coastline with the largest number of hurricanes coming our way? It might also have to do with what I am going to borrow from an association. The Florida Association of Public Adjusters has a really good graphic here that I'm going to share on our website. It's called shrinkflation. And what it talks about is as property insurance premiums go up, but your coverage comes down. Let's start back all the way in 1992. Okay, 1992, for those of you who lived in Florida, you'll remember a horrible, terrible storm called Hurricane Andrew. It cost a lot of lives and caused dramatic destruction of entire communities in the southern Florida area. And at that point in time, we start seeing upward pressure on deductibles. Now, what exactly is the function of a deductible? And if you ask someone in the insurance business on the insurance side of the aisle what a deductible is they refer to the deductible as the insured's contribution to the loss. You're going to, quote, contribute a deductible to the loss. Okay. I thought I was contributing to the premiums every month, but I understand I'm going to not necessarily be paid 100% of the loss. We get it. In fact, if you think about automobiles, that's, I think, where most people have an understanding of deductibles, is that the automobile, if you get in an accident, you have to pay a $500 deductible. Well, $500 deductible for what cars cost these days, that's not too bad if you think about it. I mean, heck, you can't even get a used car these days from less than $25,000, and you're only going to be paying $1,500 towards your deductible. Well, see, property insurance deductibles are a lot different from that. But here's an illustration of how companies like Citizens have taken real advantage of the deductible process. All right, so let's begin with, what is the average cost of a home in the state of Florida? Well, I have seen numbers varying a little bit, but I believe there's April 2022 data on this, and it states that the average home price in the state of Florida is $390,000. Okay, so if I have a property insurance policy with Citizens, the state-run insurance company, they will have deductibles for windstorm losses somewhere between 2% of the coverage through 10% of the coverage. Okay, so if let's remember, I'm a lawyer, so math is a little more difficult for me than most humans. In this context, let's round it up to 400,000. Okay, so first of all, the deductible, if you had a 10% deductible, would mean that irrespective of the amount of damage that your house may have suffered from a storm, you are going to contribute your deductible of $40,000. That means that if you have $39,500 worth of damage, you get zero from your insurance company. Now think about that. How bad would the damage have to be to cause $40,000 worth of damage? It could easily, I've seen estimates where storms hit homes and the actual amount of the damage is between $25,000 and say $50,000. And that would mean that if the damages were $50,000, that you're going to get a check from the insurance company for $10,000. But wait, there's more. What is actually being covered? Well, Citizens was really the biggest proponent of this. And of course, they can be that way because having a relationship with Citizens is difficult because they don't really want to insure you and you don't really want to be insured by them. But this isn't just Citizens. A lot of other insurance companies, private insurance companies that would be real excited to sue me if I identified who they are. So we'll just talk about it in general terms. So it's not just about the deductible. Most of you who don't live in the state of Florida may not know, but we got a lot of bugs here, lots of bugs, big ones, and we have no winter, and so they're real populated. If you have a swimming pool, for example, let's say here in the Carrollwood area, which is a suburban area here in Tampa Bay, you probably have a swimming pool. And if you have a swimming pool, you most assuredly have a lanai. Lanai, and that really is another way of calling it a screen enclosure over your swimming pool. Well, these are not cheap. If you, in fact, had to replace your screen cage, it would not be surprising to see, depending obviously on the size of the home, that the cost of that would be somewhere between $12,000 and $20,000. So let's just say it's $15,000 at your home. Well, it turns out that now Citizens has excluded from any coverage whatsoever the actual cost to reattach a lanai to your home. Now, why would they pick on lanais? That's because somebody sat down and looked at the payments that were being made on all these Citizens claims, and they realized one of the most common elements that had to be replaced was the cost of the lanai. Now, I'm not talking just about replacing one panel of screens in your lanai. I'm talking about taking out the entire aluminum core of the lanai when a storm comes through. That is the most vulnerable area of your home. In fact, some people suggest if you believe your home is going to be struck by a hurricane, that you should take a knife and cut the screen, because that allows the air to flow through and you won't lose your lanai. But let's now keep track of an average priced home in Carrollwood, in Tampa, at $400,000. We now have a $40,000 deductible, and $15,000, not included in any way, will be tacked on top of that, because you're going to have to wait until you break the $40,000 threshold to get into the pocket of the insurance company, and then you have to come out of pocket to replace the excluded screen cage, bringing us up to $55,000. And this is not in isolation. I've got lots of these, but I want to talk about some other things. But you get the point. This would mean that the average homeowner in Carrollwood, in the event of a storm, would be out of pocket $55,000, or probably the equivalent of tuition at NYU in 1 year, in order to get coverage from its insurance company. Now, would you agree with me that setting the policy up to fail like that is what's going to draw a lot of people out and look for conflicts between the insured and the insurance company? And so I say to you, there is more to this story than as simple as an insurance company saying that they get sued all the time. It's the only industry I can even think about that would do that. I mean, I don't even remember that when Big Tobacco was being sued all the time, that they whined about it, because they knew what they were doing, and they knew what they were doing would create lots of litigation at some point. Insurance companies are whining because they're covering far less and charging more, and they're getting sued because of it. And it's in a state with the most coastline. In fact, double 120, about 150% of the coastline of the next state below it, with the most number of hurricanes hitting the most coastline. Of course, there's going to be a lot of litigation. All right, let's now go on to what is unquestionably the most prolific argument in favor of charging insureds more and attacking insurance consultants acting on behalf of policyholders. Let's talk about assignment of benefits provisions. And this is the way it works, and it absolutely can be a scam. It looks like this. You wake up one morning after a storm has clobbered your house, and you observe that your roof is severely damaged and it is leaking. You reach out to a roofing contractor, and the roofing contractor comes out and says this: I don't know exactly how much your roof is going to cost, which is probably not true. Of course they know. And so what I'm going to do is I just need you to sign this document right here that says you're going to assign to me all of the benefits that you may have under your insurance policy to be paid for this roof. And in fact, I'm even going to absorb your deductible, which could be substantial. And so what's happening is that you can imagine if you're a roofing company and you now have an agreement that has an open shot to an insurance policy, you're probably not going to sell them the cheapest roof, and you're probably going to overcharge them. And that has happened enormously, happens all the time. And so, but here's the reason I'm talking about it now, not to tell you that, oh, well, there's some reason why all those lawsuits are filed. No, I'm putting it back in the context of what's going on today. Well, this is not a new issue. Here we are in 2022, and we know that this AOB issue has been floating around. And it's not just been with roofs. When I was a defense attorney handling property insurance claims a decade ago, the one that used to drive me crazy were the raccoon guys. The raccoon guys, well, what they would do is homeowners would go up in their attic and discover that there was a family of raccoons eating and chewing up wiring and insulation, and then this raccoon company would go up there and they would clean all the insulation out, and they would relocate the raccoons, maybe send them to community college. I don't know. But then the raccoons would leave behind enormous amounts of waste. They would then charge the insured on an assignment of benefits contract $25,000 or $30,000 to do all that work. And then when I was working for insurance companies back then, we would get these claims and we would say, where in the hell did they come up with $30,000 worth of poop from a raccoon? Maybe it's because they have opposable thumbs. I don't know. But the insurance companies finally got wise to that. And in 2019, they completely revised all of the statutes and relevant restoration rules associated with roofing agreements or anything associated with an assignment of benefits contract. And so 3 years ago, we saw requirements, for example, that if you are a contractor, roofing contractor or otherwise, you are required to provide a copy of the executed assignment of benefits, meaning it's still legal to take an assignment of benefits. But if you ever want to be paid on it as a roofer, you have to submit it within 3 days after the AOB is executed. And if you don't get the assignment of benefits. The insurance company can still deny the claim or pay what they believe to be appropriate. The reason it's so important for us to be talking about this right now is that we're being told the AOB issue is haunting the insurance companies in the state of Florida. It's not, because we just got rid of them in 2019. The reason why the AOBs are still being fought is simple. When the original these claims, the last iteration of them came in from Hurricane Irma and Hurricane Michael. Well, the rule is the law that was in existence at the time the policy was sold governs. If you have an Irma claim and you have an AOB that you've hired a roofing company with, this would not apply to those losses. And frankly, there's nothing anyone can do about that. We have freedom to contract, but as most people would understand, you can't go back and rewrite the law. At the time the insurance company sold the policy, at the time the claim occurred, the laws that existed at that time are what matter and not what comes later. Meaning, we don't know yet the extent to which this change in 2019 with the assignment of benefits issue, how it will positively impact the marketplace until we have another series of storms. But if you listen to the rhetoric coming out of Tallahassee, this issue is being used to really gin people up about how lawyers and public adjusters are taking advantage of these poor insurance companies. And frankly, it's just not true. Not any longer. And so we go on. We heard about too many lawsuits. We heard about the evil of assignment of benefits. And now here's one that's a little bit deeper on the pile, but it's certainly a big popular one to come after people like me. And that is what is referred to as contingency fee multipliers. All right, now let's get a little bit egghead here about what those are. In the state of Florida, if you take an insurance company to task and you recover money from them that they had previously refused to pay, pursuant to Florida statute 627428, you are entitled to recover the attorney's fees associated with that action. Fair. Absolutely fair, and no one would say otherwise. In fact, my former partner and I, Morgan Barfield, along with a very skilled group of appellate lawyers at the Weber Crab firm, took a case on attorney's fees all the way up to the Florida Supreme Court. And here was the argument that the insurance company made in that particular case. They made the argument that if they investigate a claim and deny it, as long as they can prove that they didn't deliberately deny the claim or that they didn't deliberately undervalue it, and it just happens to be they were wrong, then that's not enough. That you need to be able to establish that the insurance company's conduct was deliberate, almost evil, I suspect, or malicious, I think was the word that they looked for. But what ultimately happened is the Florida Supreme Court held the question is, Was the loss covered? And did the insurance company get it wrong? Period. It doesn't require, nor would it be something that we could ever entertain, establishing that they only have to pay attorney's fees if it was something intentional, as opposed to the idea that they accidentally screwed up a claim. Well, Florida Supreme Court said no. The answer is incorrect. Does an insurance company own its incorrect decisions? And the Florida Supreme Court said yes. I believe we're going to see insurance companies arguing in this upcoming legislative session, and I'm saying insurance companies because rest assured that many of those legislators that you're going to hear from are well funded by some of the most prominent insurance companies. And let that really get in your gut for a second. You understand that you are paying premiums to your insurance company, and they are taking those premiums and they are getting in a car and driving to Tallahassee with a briefcase full of cash and giving them to these legislators to fight against your coverage. So, wow, does that feel good to you? Well, along the way, here comes contingency fee multipliers. And what this means is there is a United States Supreme Court case, as well as a series of Florida decisions that have found that in certain circumstances, very, very rare circumstances, you can argue to a court on the calculation of attorney's fees, if you win, that not only should the lawyer be paid the amount of the fees, whatever they may be, but also that the lawyer should get more than that, meaning that there's kind of a punitive element to this, as well as a motivator, because there has been a belief that without this potential enhancement on your fees, that insureds would have difficulty getting access to qualified counsel. That's the argument. That's what contingency fee multipliers are based upon. But even within the context of the Supreme Court cases and subsequent, litigation over what a contingency fee multiplier looks like, and it kind of look like this: if your fee is $50,000 for the work that you've done, you could argue to a court that the contingency fee multiplier should be 1.5, which means take the $50,000 that the lawyer is going to be paid and multiply it by 1.5. Now the fee is $75,000. And that's the situation that we have being mentioned now in all of the information that's coming out of Tallahassee, that insurance companies are getting crushed by unscrupulous lawyers who are getting paid not just their fees, but more than that. Back up in terms of who I am. I tried my very first chair case for property insurance in the state of Florida in 1999. At the conclusion of that case, I was a defense counsel at that time. We lost, and we were ordered to pay the attorney's fees for the insured. There was a fee hearing, and the insurance company I defended on their behalf, the argument that a contingency fee multiplier was inappropriate and unnecessary. Why? Because at that time, I believed, we argued, that there were more than enough insurance company lawyers out there for everyone to find competent counsel in their community. Yeah, that might be a little bit of a stretch, but that's the argument. And the court agreed and said, no, you're not getting a contingency fee multiplier. And so since then, under my watch, I have observed literally thousands of property insurance cases being handled in litigation. And the first thing I would tell you is that 95% or more of them are never tried. They're resolved by negotiations. And no insurance company I'm aware of, and I've seen most of the most common ones that you could list off yourself, nobody negotiates a contingency fee multiplier. The only time a contingency fee multiplier gets put on the table is when a case goes all the way through the process and there's a trial. And after the trial, then they file motions for fees and they include a request for a contingency fee multiplier. And so, first of all, this argument about contingency fee multipliers are relevant to fewer than 5% of the total cases that are even filed in the state of Florida. Second of all, and prior to today's podcast, I reviewed as many cases as I could find that were taken up on appeal in the last 2 years. And out of 14 cases that I found that were associated with contingency fee multipliers, 13 of them, the appellate court affirmed the findings of the trial court that a contingency fee multiplier was not appropriate and the lawyer should not have been rewarded with it. And so 5% of the cases is all we're talking about. And what I find of 14 cases, one of them involved a case where a contingency fee multiplier would have been appropriate. And let me give you the facts of that case. That was a case where the insurance company argued that there was no coverage whatsoever, and the insured's claim was for $35,000. The totality of time it took to get that claim paid was 4 years, meaning the insurance company deliberately and knowingly denied a claim that they knew they owed, and we found that out later in the notes, and then argued and fought for 3 years before they ultimately paid the $35,000 they were ordered to pay by verdict from a jury. And they assuredly spent more money defending that case than paying what they had admitted that they owed. And you're then going to argue that the contingency fee multiplier is just so offensive it doesn't apply to those facts? Well, it's up to the judges. And the judges are the ones who have their boots on the ground in these situations and can assess the appropriateness of these kinds of factors. And so I'd rather have decisions like this made by courts, even though it's a very limited number of cases even being affected by this. And so please disregard anyone telling you that we need to solve the contingency fee multiplier problem that it has created for insureds in the state of Florida, or the contingency fee multiplier being some kind of structural argument as to why insurance companies don't want to sell insurance here in the Sunshine State. And so I hope that I've addressed some of the more common arguments that you're seeing out there. And I need you to understand that when you start asking legislators to make decisions that are preserved for courts, you lose the independence of the judiciary. You really do. And back to my joke about what in the world does it mean to be conservative? I believe that's a conservative ideology. I think it is appropriate and conservative to provide independence for judges who should not be affected by political winds. And that's certainly what we have now. We have judges that are being selected by state and federal officials because they have predetermined biases against certain industries. And here I sit representing homeowners who are simply trying to get their homes repaired, or condominium developments that have serious problems following major windstorm events, and insurance companies who are refusing to spend money to properly investigate claims that affect roofs, windows, and doors. I'm going to continue to report to you on these issues and other things associated with my practice at Corless Law Group. You can learn more about my practice and the people that I work with, the teams of lawyers that we bring to these questions, at www.corlesslawgroup.com. Be careful out there. Hurricanes are coming. This is Ted Corless. Be well.